Congress likes to have it both ways. They like to say they passed some nice-sounding law to clean our water, clean our air, and then they delegate all the hard work to the agencies to do so. And then, after a burdensome and costly regulation is passed, they can claim that they like that the agencies were doing something, but they can disavow responsibility for it. The framers contemplated that there would be certain departments and certain agencies. They came from the British constitutional system where there were departments. There wasn't a Department of Justice from the founding, but there was an Attorney General, and the Attorney General had a staff, and there was always a Treasury Department. There was always a War Department before a Department of Defense. But they were to help the president execute the law and not as a substitute lawmaking body. The main way that Congress is delegated power is to pass statutes with broad goals and very vague instructions and a lot of power to regulatory agencies. The Supreme Court has tended to allow very broad delegations since the 1930s, but those of us who believe in the written Constitution and an objective meaning believe that there really are more constitutional limits to what Congress can delegate. But even if it is constitutional for Congress to delegate that much authority to regulatory agencies, there's a question of prudence. Should it? And that's where the Congressional Review Act does impose a little bit of accountability on Congress. It's not ideal, it's not what the framers really intended for the separation of powers to work, but it does require Congress to assume some responsibility to either pass a resolution of disapproval or own that burdensome regulation. Congress should do more to reassert its constitutional responsibility over agencies. But it also needs to change the underlying statutes that grant far too much discretion to the agencies, that allow them to run amok and pass regulations that impose such crippling costs on our economy.